And Your Honor, how can this be a court of record, a criminal case, if there is no verified complaint by a living injured party?
That's 23 CR 5243, People versus Dustin Kaminsky. Can you hear me, Mr. Kaminsky?
I'm also hard of hearing, but I can hear you, sir.
Okay. All right. Can I have entries?
I'm Dustin Anthony of the House of Kaminsky. I'm here by special appearance to challenge both personal and subject matter jurisdiction.
It looks like you're represented by the public defender. Is that right?
He was at one time, Your Honor. If he wants counsel to be appointed, we can enter today. This would be my first time actually appearing with him if he wants a public defender.
So, Mr. Kaminsky, because you're in custody, you have a right to a public defender if you want one. Would you like me to appoint the public defender?
I can speak for myself, Your Honor, but any help would be also acceptable.
Okay.
I guess then that sounds like a yes. So I will go ahead. And are you Ms. Barton?
I'm Camille Taylor.
Oh, okay.
Bar number 48054.
Okay, thank you. And for the people?
Lindsay Maas for the people, Your Honor, attorney registration number 49996.
Okay. And would then this be your case, Ms. Taylor?
It would be, Your Honor.
All right. I will appoint Ms. Taylor on this case. Looks like, is this a first appearance on an arrest warrant?
This is a revocation of probation matter. It looks like we need to set bond. It was previously set at $450 cash back in 2024. So, but since he's been arrested this time, we don't have a bond set.
Okay. Would you like to be heard on bond?
Yes, please. Given that the prior bond was a cash bond in the amount of $450, I would ask for a slight increase to $475 cash.
Okay.
I would ask for a PR bond, Your Honor. I don't have any cash on me.
Okay.
Alternatively, a PR.
So, Mr. Kaminsky, here's the thing. If you have the public defender representing you, they speak for you. Okay?
Well, then I can speak for myself, Your Honor.
Okay. Well, let's hear from the people.
Thank you, Your Honor. The people are recommending a $600 cash-only bond. We'd note for the court that Mr. Kaminsky was initially on a probation revocation summons. He showed up for his first court date several hours late, avoiding a warrant at that point. He failed to appear at his next appearance, and it would seem that while on failure to appear status, Mr. Kaminsky has picked up an additional felony case in Boulder County. We do believe that the increased cash bond value is appropriate based on the failure to appear as well as the other records made by the people. Thank you, Your Honor.
Your Honor, that felony case out of Boulder County was dismissed, and they also entered a motion to quash the arrest record. And it was signed by the judge in Boulder County.
This courtroom exchange is the perfect example of why sovereign citizen arguments fail almost every single time. Commentary. Dustin Kaminsky walks into court insisting he's appearing by special appearance to challenge jurisdiction. Sounds dramatic.
Okay. Well,
So there is no felony case out of Boulder County at this time, sir.
All right. Even assuming that that is true, I'm going to find, based on the failures to appear in the history of this case, that a cash bond is appropriate. I'm going to set bond at $500 cash only, with all original terms and conditions. Okay. There's been a complaint filed by the probation department. I find that that's appropriate, and that this is a court of record for that purpose.
And then, Mr. Kaminsky, you have the right to a revocation hearing within 14 days of today if you want to set immediately. That would be an evidentiary hearing where the prosecutor would have the burden to prove that it's more likely than not that you didn't comply with your probation. So you could set that today immediately, and the judge would have a 14-day timeline in which to hold that hearing. Otherwise, you could waive the 14 days and set that hearing literally any time, whether you're in custody or out. I would rather meet with you to discuss the allegations before we set a hearing, which would require you to waive the 14 days. Are you okay with taking that approach?
I don't have the $500 cash on hand, so I'd rather just take care of this right now.
We can't either way, we're not taking care of this today just because I haven't talked to the DA about a plea offer and I don't even have a copy of the complaint against you.
Okay, I completed treatment. I completed
But Mr.
the
Kaminsky,
class that was required.
don't even have a copy of the complaint against you.
Okay, I completed treatment. I completed
But Mr.
the
Kaminsky,
class that was required.
Mr. Kaminsky, don't talk about the facts. So I'm going to chat with him if that's okay, counsel.
That's fine.
So, Mr. Kaminsky, as your attorney told you, you have a right to a hearing on the complaint. Because you're in custody, you have a right to that hearing within 14 days. If that's what you want, we will set a hearing for you. Your attorney would like some time to talk to you and see if she can reach an agreement with the DA. That may take more than 14 days, and that's how this is typically handled. If you want her to try to do that, you would have to waive your right to a hearing within 14 days. We'd set a status conference at a time that the attorneys agree to, and if you're not able to reach an agreement then, we would set a hearing. So do you want
Well, I
me
don't
to
see
set-
why my attorney couldn't handle this within 14 days and review the evidence and also review with the district attorney. I'm going to be sitting here since I don't have bond. Would the court
All right.
consider a PR bond?
No, I wouldn't.
I would be able to prepare better for
Mr.
this
Kaminsky,
case.
you need to let me talk now. I'm going to find that he's not willing to waive his right to a hearing within 14 days. We will set a hearing. If the attorneys are able to work something out prior to that hearing, that's great. But if not, we'll give you your hearing within 14 days, okay? Can we
you.
get a date?
How long do you need?
Can we please have an hour, 45 minutes?
I can do August 8th at 2.
August?
Or, I'm sorry, April 8th at 2.
Does that work for counsel?
April 8th at 2. That'll be fine.
We can accept that, Your Honor.
All right, so Mr. Kaminsky, your hearing is going to be April 8th. That's a week from now, more or less, at 2 o'clock. Your attorney will, I'm sure, try to be in touch with you before that to talk to you about your options and to prepare for a hearing if there's going to be a hearing. Okay?
Okay.
All right, thank you.
Have a good morning.
You too.
This courtroom exchange is the perfect example of why sovereign citizen arguments fail almost every single time. Commentary. Dustin Kaminsky walks into court insisting he's appearing by special appearance to challenge jurisdiction. Sounds dramatic, until the judge calmly explains that none of those arguments matter at this stage of the case.